Anna Vitarte, would you mind opening us up in a word of prayer? Sure. Thank you. What are you, 14?
Dear Lord, thank you for bringing this committee together, do the will of you and the people of Georgia. Just want to bless the individuals in this room and the people presenting to us, and just be with us as we make decisions. Amen.
Amen. Thank you, Senator. Our first item of business is to adopt the Senate rules. You'll see a copy of the committee rules in your folder. Thank you very much. Anybody have any questions on any of the proposed rules? If not, do I hear a motion?
Second.
Thank you. A motion by Senator Anna Vitarte, second by Senator Beach, to pass as in your folder. All those in favor, please say aye. Aye. All those opposed, nay. And the rules are adopted. And take a point of personal privilege before we get started here with Senator Thompson's bill to congratulate our now official resident attorney, Mr. Beal. He was Mr. Beal, now he's Counselor Beal. So he just passed the bar recently, so congratulations. And on his first time through. And we think we think that it's about 1/3 of the people don't make it through on their first time through. I would not have made it through on my first time through had I done it. So congratulations, and you now have to call him counselor. That's not in the rules, but we'll adopt that as an unofficial rule. First up on our agenda is Senate Bill 52. Senator Thompson, and you all should have a copy of a committee sub in your folder. And Senator Thompson, why don't you take it away?
Thank you, Mr. Chairman. Members of the committee, I appreciate the opportunity to present to you Senate Bill 52. We should be reading off of LC 48032-7S. I want to ensure everyone has a copy of that because it is a sub. Is that correct, Mr. Chairman? Everyone has that copy?
It's looking like no.
Absolutely. 48032-7S. And
do you have copies of the sub that you can distribute?
Mr. Chairman, I apologize. That sub was being prepared kind of a little bit late. We did electronically send that out,
That's
so
okay.
my apologies if there's a delay in that.
I have mine. I don't think that any of them have theirs, though. What's the LC number on that, Cam? Okay, perfect. Yeah, if you could distribute that to everybody. Everybody good now? Great. Excuse me, sir? Sure. Cam can get you a copy of that. Absolutely. And if, Cam, if you get one to Senator Au as well, please. Go ahead, Senator.
Thank you, Mr. Chairman. I'll begin by stating that we brought this bill before this committee last year, or before this body last year, and we passed it almost unanimously out of the Senate. It moved through the process in the House, and then, as we know, politics, sometimes other bills hold things up. So this is not a new issue being brought before you. We know in our state, as well as the nation, cybersecurity poses a great risk to our business community. Many of your larger businesses have the ability to hire chief information security officers as well as teams to manage their data and anything that they're storing. So in the event that they may have a cyber attack, they're able to identify some of those and maintain the equipment and protection necessary. Our smaller businesses, many of them know that our communities are made up of small businesses. As a matter of fact, if I may, I'll talk to you just for a second about what this looks like. On average, every 39 seconds, there's a cyber hack. 43% of cyber attacks target small businesses. 150 million is the average cost of a data breach. So keep that in mind, 150 mil. Data suggests that cybercrime cost businesses over $2 trillion in 2019. Data breaches exposed 4.1 billion records in the first 6 months of 2019. As of 2019, cyber attacks are considered among the top 5 risks globally, and the global number of web attacks blocked per day increased by 56.1% just in those 2 years. Now, of course, we'd have COVID and other things, but if you think about COVID, COVID gave the hackers an environment that is even more rich for cyber attacks. I bring this up to say that our small business community is ill-equipped in many cases to be able to defend themselves when there's a cyber attack. What this bill seeks to do, it's called a Safe Harbor Bill. It is supported by our State Privacy and Security Coalition, of which you should have members. You should have a copy of a letter of support, as well as a Georgia Chamber that will help present this bill as well. But in essence, what it says is that there are some standards that are set in place. A small business can go out and either abide by these standards, or they can hire out a company that can do this. So think of it as this way, as maybe you run a company and you don't necessarily have a CPA on hand, right? But you can send out your records, your financial records, and have them stamp that as certified, and that's acceptable. This would be the same kind of principle, in that you could have an outside company as well as inside that meet these standards. In the event you get attacked, as we've all talked about this, it's not if, it's when, you would then have an affirmative defense that you found yourself in court. So you could say, listen, we weren't negligent. This was a crime that was committed on us, but we made sure everything we were doing, we could preserve the data and so on. So it doesn't change anything in the legal community other than the fact that it does say we're able to have an affirmative defense against this, and hopefully in some ways we're able to prevent some of these major losses that happen to these small businesses that evidently if they get one of these attacks, and then current times we have right now, it turns into a multi-million-dollar claim, they're out of business. It's the neighbors that you have. It's the friends that you have. In some cases, it's your businesses. They're out of business. They can't afford these claims. So, Mr. Chairman, I'd like, if we can, to have Danielle from the Chamber to come up. She can kind of walk us through some of these provisions. But again, this bill has already passed through the Senate almost unanimously last year.
Danielle, go ahead and come forward, please. Present the bill. Thank you.
Thank you so much, Chairman and members of the committee. As Chairman Thompson said, this is a top priority for the business community and has been for a couple of years. We actually started this initiative back in 2018 to look at proactive cybersecurity measures that would benefit Georgians and Georgia businesses. We wanted something that would really make sure that consumer data was protected, and that, of course, our businesses would be able to operate in a predictable environment and really be able to thrive and grow jobs, drive investment, all of those top priorities for our state. So back in 2018, we actually convened a group of cybersecurity, data protection attorneys, technology companies, risk management companies, all to discern what those potential solutions could look like. What are those measures? And we actually saw a similar bill in another state. It was in Ohio. They had a Data Protection Act. And as Chairman Thompson mentioned, the great thing about this is that it really is scalable to a Fortune 500 company or to a really small business. So something that is 25 employees, which is really what we liked about it. There's no minimum standard, but it just allows businesses to go to the absolute highest standard to protect consumer data. As Chairman Thompson also mentioned, COVID has been a real, impact, of course, across the economy. There are actually 1.8 million new visible internet host site platforms and a 775,000 spike in cloud usage. So as we're seeing, this is being, really driven across the state. There's increased digitization of everything. Through the effort of our Resiliency and Recovery Task Force that we launched back in 2020, cybersecurity again emerged as a top priority to continue to make sure that our state can recover and thrive and become even stronger. We think this is a bill that will really increase our competitiveness and continue to provide for an adaptable economy to serve the state of Georgia well for years to come. So I'm happy to answer any questions about the bill or talk through any additional information. Thank you for the opportunity.
Great. Thank you for being here. And I missed this as you were walking up. Can you introduce
Sure.
yourself, name, and where you're from?
Sorry about that.
No worries.
Daniella Perry. I serve as the Vice President of the Georgia Chamber Foundation, overseeing our policy and strategic initiatives as well as research.
Great. Do we have any questions for either her or Senator Thompson? Please have your seat.
Thank you, Mr. Chairman. I'm fibbling over here because I was trying to see the change, the difference, while we got one thing and then in presentation. So are we just doing a hearing now, so we'll take action later, or are we planning on taking action on something we're just being presented?
I had planned to take action, but if it's the will of the committee to do otherwise, we can entertain that. Senator Thompson, do you mind walking through the difference between the sub?
Yeah, absolutely. I can talk through those changes. So if you look on line 13, which is that general purpose section, we just clarified that to make sure that it states that the purpose is to apply to tort litigation and regulatory enforcement.
Great.
And then on lines 30 to 31, we just cleaned up the language there to make sure that it aligns with our existing state data breach statute. And then if you look at lines 51, we added some more specific verbiage around the type of health data impacted, just to be specific in what we were looking at there.
I think that's actually lines 56 and 57, is it not?
Apologies there. And then a little bit farther, it was line 68, but again, it was just a quick change to conform to our existing data breach statute because we do have an acquisition statute in the state of Georgia. So all the changes were very minor, they're very specific, but we really wanted to make sure that we did our due diligence to make sure that everything really conforms well to our existing statutes, but they were small changes. They were in the original bill last year that passed through. So when we went back through, just double checking that we made everything in accordance with what was there last year that passed out of the Senate.
Senator Steve, any further questions?
Well, I'm still, unlike you, that can pass on the first time. I'm no attorney. And I just can't get it that fast, Mr. Jackson. So respectfully, I mean, I take your word for it. We've been colleagues for a long time. But I haven't had my time to go through this bill, and I'm just not comfortable with taking actions at this point. I just need time to, I mean, either we're gonna have another meeting, right? Is it a real reason why we have to do it today?
There's not. I would, I guess, seek the will of the committee to see if anybody else has any questions, but if the rest of the committee is comfortable, maybe we move forward, but if not, we can wait. Senator Al, you're number 4.
I just have one question, or one point, I guess. I think the overarching intent of this bill is good. I do think we should obviously establish safe harbor for companies that are doing good work, especially if they're criminally hacked by an outside agent. However, I worry, or I wonder if the way that these protections are structured in this bill accomplishes the goal that we've set forth. In particular, I think when I read through it, and maybe you can walk me through it, because, you know, I'm not a lawyer, right? So when you use the term substantially comply, that verbiage, that type of language, I wonder if that doesn't define as well or specifically what that compliance should include. And I do want to go back to this one point that's related to your third point in your substitution. I did notice when we were reading through it in terms of the privacy information that needs to be protected. On first pass, it was a sort of medical information, and you changed it to a health medical record number or identification number affiliated with their insurance info. And just related to that and the type of cybersecurity and the degree to which that cybersecurity is delineated, even in other laws, I wonder if it's not specific enough. And I'm just going to I pulled this up earlier today, related to HIPAA security rules related to cybersecurity, and the degree to which it really spells out, not just like good faith or substantially comply with, like, you know, what was the language you guys used? What did it say? Reasonable administrative safeguards. I wonder if that's too broad and it doesn't get at the specifics that we need, because I wonder if not putting the specifics sort of incentivizes companies to maybe do a head fake towards what seems like a reasonable cybersecurity measure, but not actually enact the degree to which, for example, medical information needs to be encrypted and encoded because it's, you know, maybe cheaper or easier to not go through the full rigmarole. Can you speak to that if it disincentivizes?
Yeah, of course. So we actually were not able to specifically reference HIPAA because here in Georgia we have a non-delegation clause in the Georgia Constitution that doesn't allow you to reference other standards. You have to have everything actually written out in statute. So like in Ohio, they actually list like HIPAA as a specific thing. So we work with our data privacy attorneys, and they assured us that this is language that's used across states. It's actually in New York SHIELD Act right now. So it mirrors what's in contractual agreements all across cyber deals, and it's actually in other state statutes. So this is actually very common language that's used to define these exact instances. So this is something that really is being specific. It's one of these are all very normal legal terms used in these agreements that really does, generate that kind of compliance that we're hoping to get, but we were not able to reference HIPAA, and that was something that came from legislative counsel.
Sorry, and just to clarify, when you say the language, do you mean the language of substantially comply, or do you mean the language of health identification number / unique identifier? Which one are you meaning?
Right, so actually both. So the substantially comply with something, again, that we worked with our data privacy attorneys, said, what is language that would make sure that we are getting those exact same goals, that we're getting that same kind of compliance with really, really high cybersecurity standards, because again, our goal here is to make sure that we've got Georgians and Georgia businesses well protected, and they are kind of complying to that. But the health data privacy was also something that was a recommendation of some data attorneys, just to be, make sure that we're not capturing, more information. That's, something that we want to be specific, that we're capturing the right data.
Got it. Thank you for explaining that. And then just back to, not to belabor this point, but the issue that it's not specific enough in terms of the degree, or sort of enumerating the degree of security that needs to be enacted. Can you speak to that I sense that it may be too broad? The language in the bill doesn't actually
Sure.
push protections at the level that we would want for this type of protected information?
Right, so this actually is language that's in the New York SHIELD Act, which is their legislation. So it is, again, the exact kind of language that you would want in this kind of agreement. It's used in contracts all across, data privacy negotiations and contracts, but this is something that's very common language that's used to generate a really high level of compliance. This is what you would want utilized. We made sure to really do our due diligence with our attorneys and make sure that we found the exact right verbiage to make sure that we're still getting that really high adherence to the gold standard.
Thank you.
Of course.
Thank you, Senator Dow. Any other questions? We do have somebody signed up to speak on this, and he wrote his name twice, and I can read neither of them. But it's Mr. Edward, I believe it's Piasta, is that correct? If you could,
That's correct, sir.
you can approach the podium, introduce yourself, please, let us know where you're from, and we'll give you 3 minutes to outline your objection to the bill.
Okay, thank you, Senator. My name is Edward Piasta. I am a Fulton County resident and a citizen of the state of Georgia. A little bit about me: I'm a Georgia Trial Lawyers Association member. I am a small business owner of Piasta, Newbern, and Walker. Our office is by the ballpark, where I do have experience.
I just want you to spell your name. I'm writing it.
Piasta.
Thank you.
You're welcome, and thank you, Senator. Our office is by the ballpark of 8 employees. We're a trial firm that represents both victims of personal financial injury, both individuals and small businesses, and some medium-sized businesses, depending on what level you talk about. A little bit more about me, where I sit, is that I'm a military officer, a career military officer. Brought me to the state of Georgia. Originally from California. I'm a lieutenant colonel in Georgia Guard. I was on active duty, met my wife. And now I'm the Chief of Military Justice for the Georgia Army National Guard. I'm also a devout Christian, Catholic, and all that implies. So that's a little bit about me, since I've never been before the Senate committee or any Senate committee for that matter. I oppose this bill for a variety of reasons, but primarily what an affirmative defense is immunity. It means that small businesses, large businesses, gigantic businesses alike get carte blanche immunity for 2 reasons. Either that they get a license once a year, is where it's at the end of the bill, and I have it as page, on the one before this committee, it's lines 112 through 118 is an affirmative defense. An affirmative defense is not an assessment of negligence. That's an assessment, no matter what, carte blanche, you are immune from lawsuit. You get a motion to dismiss the moment it starts. That has significant consequences. The certification they're talking about on lines 115 to 118 is that if any organization, I'm thinking like a bank, just gets a security audit once a year and that's it, they can, according to this bill, the unintended consequence, they could press timeout, do nothing for a year, and any lawsuit will be barred. That is what this says. I don't think that's the intended consequence. I do think encouraging small businesses to follow protocols is important. I think it's a little overstated to say that it's unreachable. There's Box.com, there's Dropbox, there's Microsoft, Amazon, all these have very high encryption levels that are known to the public with dual, and it's cheap. I'm a small business owner, it's not a problem. There's a lot of things out there to prevent against cyber attacks, but the bill as written creates a carte blanche immunity for essentially be like a driver passing a driver's test, and then for the next year could do whatever the heck they want on the road. And then the next year they take the driver's test and do whatever the heck they want on the road thereafter. That's what this bill says. That concerns me. That's why it brought me to the Capitol for the first time. I've been to the Capitol before, but I've never spoke. And this one, I don't think that's where our state wants to go for its citizens. It shifts the entire risk of loss from large and small corporations alike down to the consumer. We all have bank accounts on our app. If Wells Fargo just said, and by the way, I like Wells Fargo, not disparaging them, but if they were to say for the next year, because we got a security audit, we're going to drop all security protocol, this bill, as written, says they're immune. And so we have a problem with that. Also, substantial compliance is an or. So there's two ways you get immunity. One is you get the license, you get the security audit once a year. The other one's substantial compliance. And to get immunity, I propose to the Senate that more should be required to get immunity. So there's two tests for immunity. One is you just get the security audit. That's frightening in implication. I can only think of a bank getting attacked. Every consumer in the state of Georgia, if somebody's asleep at the wheel, their money could be gone with no recourse. As a small business owner, I put my general counsel hat on, and I think what's the incentive to have cybersecurity insurance to protect the consumer if there's a carte blanche immunity just for me to get a license once a year? So ultimately, I think this bill, the principle of encouraging small businesses and large businesses to follow security protocols is really important. I think it's a good cause. I think my purposes of my comments are not to say that this committee should not do something, but as written, it is not what I can imagine is the intended consequences, because the bill really swifts the pendulum of the risk of loss entirely to everybody in this room and your constituents. And I think there should be more. Another example is they were talking about contracts in the proponent of the bill. Well, contracts are between two companies. I make contracts all the time between companies. And when you make a contract between a company, one company breaks the contract, you sue them. So that's not relevant to then saying, hey, if a company gets a security audit once a year, we're then going to let everybody else who's not a party to that contract take the financial cost of their mistakes. So I think that there's a way to make something like this work, but as written and as proposed, has dramatic consequences that should be considered. So I appreciate the board's time, Mr. Chairman. I'll answer any questions we have, and it's a really interesting process. I really enjoy being a part of it. Thank you.
Welcome to your capital, and thank you for your service.
Thank you. Thank you.
Do we have any questions for Mr. Piasta, sorry.
Yes, you got it, Mr. Chairman.
Senator C.
I just want to make a comment. Not only welcome, but thank you. I was already having a little bit of trepidation anyway because I know I'm not a technology person. My grandchildren run rings around me. But I love being on this committee because I learn a lot. And a change at the actual meeting gave me pause, and I expressed that. And you have now kind of solidified my trepidation, and now I'm ready to say I'd like to just table it till our next meeting so I can have time to at least understand and hear what you're saying, as well as understand the change of the bill. I hear that, and I trust my colleague, that you know, it's the same we passed out before, but even though I hear it, I just like to verify.
Thank you, Senator.
So, yeah, thank you.
Any other questions, Senator Au?
It's a real quick one. Just to refer back to a pretty prominent cybersecurity case that we've all experienced and that I was involved in also with Equifax, for example. If you took that case of Equifax, and I understand it's not totally analogous because it's a state level bill, but under the conditions that are stated in this bill, would Equifax be held liable for their data breach that, that affected so many people?
In candor, I'm not familiar, well, I mean, I'm familiar with the Equifax from a news thing, but I really focus on this, like, you know, I'm not nitty gritty into the facts. But what I can say is it would be extremely easy for a company under this bill to get their security audit once a year, which any large corporation does, and even most small corporations do. And as a small business, we monitor security all the time. But to do it once a year, then to turn the other way and not care. So this bill is,
Sorry, Cam, you give that to Senator Hufstetler, not Mr. Piasta. This is a different bill.
okay. Yeah,
Unless you want to comment on this one as well, it's
no,
coming next. but-
well, I'll read it out of interest as a concerned citizen. But my understanding is from what I've been told, is Equifax would have been immune, but I don't know the actual implications. I'm not willing to put my name behind it. What I can say is that this bill is written. I know how small organizations work. I know how large organizations work. I've represented them all. That this bill is really problematic for pretty much every Georgia citizen, period. I can't imagine a bank, you kind of flip through, they talked about the standards being what everybody would want, and one of the things they talk about is, I'm trying to find I circled it.
Mr. Piasta, I'm going to cut you off
Oh,
there. Just
thank you.
I feel like you've sufficiently answered Senator Au's question.
Oh,
Do you have any other questions for Mr. Piasta? Great, thank you. And
Thank you,
again, thank
Senator.
you for your service. Senator Thompson, would you like to offer any closing remarks?
excuse me, sir, thank you.
Yeah, I appreciate it. I appreciate the citizen coming forward. He mentioned that he is part of the Trial Lawyers Association, but I've just got confirmation. He is not here representing the Trial Lawyers Association, so I'd like the committee to understand that, okay? He's coming here as a member. I also have just got confirmation that they dispute the fact that Equifax would be immune to this, okay? So I would like the committee to understand something. This bill went through judiciary last year. Judiciary is made up primarily, Mr. Chairman, of attorneys. Our recently appointed, our good friend Jesse Stone, and many others. It went through 9 iterations. It passed out. It went over. Where did it go? Judiciary over in the House. It was moving through their judiciary. So I find it a little surprising that all of a sudden we now have some concerns about something that went through a long vetting process with a group of attorneys and many other outside counsel from the various companies, from TAG to the Chamber, the Metro Chamber, the Georgia Chamber, and so on. So I appreciate the concerned citizen that comes here and voices their opinion. I think every day we let this go, especially in the posture we're in down here, allows the small businesses to be at risk. So again, Mr. Chairman, it's the will of the committee, but I would debate whether or not an opinion supersedes what this committee and or the senators that were down here on judiciary have already gone through and vetted. Thank you.
Thank you, Senator Thompson. Now entertain a motion.
Mr. Chairman, I'll make a motion.
Senator Invitarte, your mic is on.
Mr. Chairman, I'll make a motion for us to adopt committee substitute LC 480327 S. Yep.
We have a motion. Do we have a second?
Second.
Second by Senator Beach. We'll go ahead and call the vote. All those in favor, please signify by raising your hand. All those opposed, like sign. You all are going to make me vote on my very first bill as a chairman. It's a tie with, it's an even split vote with Senator Anna Vitarte and Beach voting in the affirmative, Senators Au and C voting in voting nay. I will vote with Senators Beach and Anna Vitarte, and the bill passes out of committee with the recommendation of due pass. LC 480299. Counselor, did I miss anything? All right. So our newly minted counselors informed me that was a motion to adopt the committee sub. We now need a motion on the adopted substitute. So I'll recognize Senator. So it's a motion to do pass by committee substitute. Thank you. All those in favor, please signify by raising your hand. All those opposed, like sign. Senators Anavitarte and Beach in favor. Senators Au and C opposed. I will vote in favor as well. And we now do pass by committee substitute. Thank you all for coming, and thank you for coming as well.
Thank you, Mr. Chairman. Congratulations, 2 in a row.
Yeah, thank you. All right, we're going to move on in our agenda, and I believe everybody should have a copy of another committee substitute. This is Senate Bill 53, and we have the esteemed Senator Huffstetler here to present the bill. And Senator, we'll turn it over to you.
And I appreciate that, and I apologize for the sub. I will explain what that is in regard to. Part of it is your newly official counselor's opinion that I saw this morning, and in talking with Calvin Rhodes of the GTA, a small tweak to it. But the purpose of this is, and I don't really have too many bright ideas of my own, but whether it's surprise billing or marketplace facilitator or anything, I find other states what they do and what works. They seem to always work better than what I think in my mind would work. And this was a case of where Utah had put in a law that's been in effect for about 3 years now that requires consistency among all the agencies with their websites. And I'm nowhere near the expert on that area as the chair of this committee or as House member for Forsyth County as well are better versed on that. But I am bringing this bill, and it deals with several things. One, being able for the handicapped, whether it's blind or other disabled things that deaf that maybe couldn't hear something, to be able to get that information in a different format, just like we do now with when we give those that are deaf sign language and things. So it would make it available to those. It would make that it has to work on mobile phone devices, and it requires some consistency. Every time we have a website, there's always a big learning curve trying to figure out where it is. We've got quite a few broken links in things in the state, and we've got some good websites too. I don't want to say that we don't, but it would require them to be consistent across this. So the purpose is making it accessible for individuals with disabilities, to make sure we're consistent with state and federal protocols, and allows us to use this for data analytics. And so they've got to be compatible and not be in silos that don't work in other uses that would work across our technology. The reason for the sub is looking at the very fine print in the bottom from James Bill's issue. I know some of the problems we've had, particularly maybe with DOL or something on websites, that he pointed out that this would not include constitutional officers the way agency is defined. And in talking with Calvin Rhodes, and I've talked with him in the executive branch both about this, he had the same concern talking to him today, that, well, that definition doesn't include the constitutional officers, and I didn't realize that. So I got with legislative counsel, and they put in a sub that basically changes that definition on the second page to include departments headed by elected constitutional officers of the state, so that we can include them in this as well. As I said, this has made, and other things, that there's these standards that are called, I think it's W3C, Web Content Accessible Guidelines, in Section 508, that say you've got to have formats that lets people change the font from small to medium to large, that that flows properly, that's easily used by different people. And so that would be the intent, that we meet those standards in Georgia just like they have in Utah. With that, I'll certainly entertain any questions. And lines 25 there through 27 is really where the sub is, that says it will include elected constitutional officers. That's really the only change from the other one, because that was really as much of my intent as anything for constitutional officers, and that definition, according to your Senate research and Calvin Robes, was not met under the current agency definition, as they both pointed out to me today. With that, any questions from the committee, I'll entertain.
Thank you, Senator. Anybody have any questions for Chairman Hostetler? Senator C., don't be shy.
It's really.
It's why we're
I've
here.
Never been shy, but contrary to the previous bill, at least it didn't have as much change, so I was able to get through and kind of be okay. And I know we can't help what we do, but respectfully, if we're getting stuff that's going to be a sub, at least give us a little time, Mr. Chairman. I'm just not quick as my brilliant one here, but I'm just saying being respectful.
Sure.
But thank you.
And if I could address that, I do appreciate that, and I apologize. The only change is that this will include departments headed by elected constitutional officers. And seeing the research from the experts, your attorney and the head of GTA, I realized that that was a flaw in this, and wanted to have that included today. And Sean Marie's story that had worked on this brought the changes here. She talked about bringing a letter that would say, because we do that sometimes, authorize them to make the changes. And my preference was that you had the exact language there, and that's why she changed it to that.
Thank you, Senator C. Any other questions for Chairman Hofstetler? What's the will of the committee?
I'll make a motion.
Senator C., your mic is on.
Second.
Senator, do pass. Actually, this is a sub, so
I'll do pass by substitute, Mr. Chairman.
are we in line with
Did you
that,
want me to-
Counselor? All right, we do pass by substitute, a second by Senator Beach. All those in favor, please signify by raising your hand. And the vote is unanimous. Thank you, Mr. Chairman.
Thank you. Appreciate the committee's latitude on my missing that one thing.
And we have nothing else on our agenda, so our committee is adjourned. Thank you all.